Hey everyone, Harry here to talk about the state of play for immunity for Donald Trump that is really advancing and very forcefully against him in the civil realm. So just to set this up, we already have law from the Supreme Court that says when you sue someone, not just someone, when you sue a president of the United States for action she or he has taken during their tenure, there's a large measure of immunity. You cannot recover. Indeed, the case cannot go forward if the actions that you're complaining about fall within, you've heard this term by now, the outer perimeter of the president's official duties. So we can maybe think about this as the shooting someone on New York on Fifth Avenue standard, although that, of course, would be a crime. But the basic notion, Trump has as many and in some ways as menacing civil suits proceeding against him as criminal suits. And we now have a couple which are more and more reinforcing this standard. That standard is trouble for him, to say the least, because we also have in other cases, not immunity, but ones growing out of January 6th where the legal question is quite similar. For example, can the United States step into the shoes and defend Trump? Or does the crime fraud exception to the attorney-client privilege apply? That also have to do with, was he basically president here, even under an expansive notion, or was he not? And the courts seem to pretty easily, with not breaking a sweat, say trying to overthrow the government and as a candidate trying to overthrow the ruling of the people, that Biden is the president, and reinstall yourself. That ain't even within the outer perimeter of official duties. It's, of course, for starters, a scurrilous thing to do. But in addition, you're acting as a candidate, and that's different from acting as a president. Okay, so that's happening in the civil realm. And I just want to underscore how Trump is now beginning to lose these in a very sort of back of the hand summary way. So in the E Jean Carroll case, he asked to put everything on hold. He had moved for immunity in the federal courts, and that case is in federal court. And the Second Circuit, the trial court, the Court of Appeals, had denied it. And he said, okay, but leave it there until I go to the Supreme Court. And the Second Circuit said, sorry, this is just not weighty enough to grant a stay and keep the proceedings on ice while you do whatever you try to do in the Supreme Court, which is unlikely to grant cert. So, a real indication, because tie probably goes to the stay if it's a claim on immunity that they think he's got a shot at. So it's another way of saying, you're on this one, civil immunity in E. Jean Carroll case, you're toast. And then likewise in the DC circuit, he's been sued 3 times, I think, in DC, not by, again, civil suits by people who were injured on January 6th. One involves members of Congress who were, cowering under their desks and otherwise injured. And the one in question here involves a couple police officers. And those officers are suing him. And it went up to, there was a holding that he doesn't have immunity. And it went up to the Court of Appeals, and an opinion yesterday by 3 judges, including the chief judge of the DC Circuit. Not only did they give back of the hand treatment to his claim, very short opinions, saying no immunity here, but they actually said this opinion doesn't merit publication. I was a clerk on the DC Circuit, and that kind of treatment is reserved for really kind of, easy, nobody could really contest or dispute. This is just, no sweat kinds of decisions. So they're saying too, we have, the Second Circuit, which is arguably, well, along with the Ninth, and it's one of the most important circuits, and the DC Circuit probably is the most important, saying you're a dead bang loser, and the civil standard is outer perimeter. So that really makes that very clear. Okay, now let's just take the lesson for that. This is the final point for the really important immunity motion. That is the one that he's brought from Judge Chutkan's denial in a criminal case. So that is a question that the Supreme Court hasn't addressed. It's now in the DC Circuit because remember, the Supreme Court denied Jack Smith's motion to give it very quick treatment. And I think that was by virtue of the fact that the Court of Appeals in DC is giving it such quick work. The Jack Smith's brief is due this Saturday, I think, the 30th. Yes, tomorrow, and then Trump has till the 2nd, and then the oral argument is on the 9th, a week from Tuesday, and they'll probably decide it quickly. But anyway, it seems to me that if it's so plainly established that a president doesn't have immunity for acts taken outside the outer perimeter of their official duties, that at the very least, the same rule will apply in a criminal setting. Because if you compare a civil case brought by a private party against the president alleging defamation, or, you can always sue. You can sue the president sort of for anything. The Paula Jones case against Bill Clinton, it's an easy enough thing to do. Whereas a case brought by the United States Department of Justice against a former president for conduct taken while she or he was president, that's a weighty matter, and it to me, at a minimum, would merit the same. The president would be able to parry it only no more than they could a civil case. So I think the fact that this civil standard is being so really reinforced as almost not worth additional thinking about it suggests that Trump is in big trouble in the criminal side of things, because it's quite likely that the courts will hold something no more expansive in a criminal setting. And on the facts, he has only the very weakest of arguments. This is where he's tried to reconfigure what he was doing after the election, is just looking after election and integrity in the states, something he has no business doing, but in any event sort of sounds quasi-official. But any court who's really applied the facts to the law says, what he was doing was trying to overturn the results and benefit himself as a candidate, etc. So all that stuff happening on the civil side, I think, augurs poorly for him on the criminal side, which, as we know, is moving quickly, or it is in the DC Circuit. We hope it will continue to, and it's the main roadblock between where we are now and trial actually commencing in Judge Chutkan's courtroom on the January 6th charges. So big issue, and the progress on the civil side indicates that the one on the criminal side anyway will be bad for Donald Trump. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.